responsive records to American Oversight's requests at issue in this case. And as the court knows, all of those requests relate to a matter of high public interest, the Assembly's investigation into the 2020 election. This court has already said that whether records exist and whether there were proper searches for those records is relevant to this case. Also relevant is whether responsive records existed that were deleted despite a request for those records having been made. And everyone in this case, I think, agrees on that that's the law. You can't delete records after a request for them has been made, even if you're in the legislature. That's under WISStat section 19.35 sub 5. But discovery so far has revealed some concerns. We've received evasive responses to written discovery that attempted to get to these issues, and that's more subject to our motion to compel. The depositions of Mr. Voss and Mr. Fawcett to date also did not shed light on these issues because they, generally speaking, they couldn't recall what had been done to search for or retain records, and they often passed the buck off to other staff. But the one thing the depositions did reveal is this, I would call it a highly dangerous environment for document retention in the Speaker's office, with very little, I think, apparent care taken to ensure records responsive to open records requests aren't deleted. And so our attempts to learn what was deleted and when is highly relevant. So that's why we've sought to depose Mr. Richter, who would have knowledge of this information, and we're opposing the motion for a protective order. Now, Mr. Stadler spoke to Mr. Richter's, to all of the requests in this case as having been in the past. But as we pointed out in our response filed earlier, on Friday, the time period of Mr. Richter's employment is relevant at least to 4 outstanding requests that have not yet been responded to, and that are the subject of this complaint. And those were submitted in August and September. And what Mr. Richter is the one with responsibility for searching for records on various Voss accounts. That was also established in the deposition. So Mr. Richter, in our estimation, could testify about whether responsive records were received, how they were searched, are they still being searched, where are the records now? He has access to those accounts now. He could also provide information on the office's retention practices. This, as I said, has turned into a very concerning issue, and Mr. Richter appears to control Voss's government accounts, or at least some of them, and only he and Mr. Voss have the ability to send from those accounts. And he could provide information on others with knowledge in Mr. Voss's office, since that is information that counsel hasn't provided when we requested an alternative witness. Now, Mr. Stadler referred to Ms. Ledke, who had the position before Mr. Richter. She's no longer with Speaker Voss's office. They cannot produce her. We've tried to serve her at the last known residence we have for her multiple times. The most recent information we have is she may have moved out of state. And Mr. Stadler has not identified another witness that might have information that was available to Mr. Richter and Ms. Ledke. They were sort of the front office administrative assistant types, and I find it hard to believe that somebody didn't know what they were doing, although Mr. Fawcett didn't in his deposition. We did notice the deposition about, it was at least over a week before it was going to happen. We thought that would be sufficient for the witness to be produced, so we only subpoenaed the witness the morning of the deposition when it became clear that the defendant was going to require a subpoena for him. We again thought the notice of deposition would be sufficient, and there was never a motion to quash. There's just a motion for a protective order. So I think that demonstrates that this witness is considered a party witness and not a third party. And so the notice of deposition should have been sufficient to bring him to the deposition. The council has expressed some concern about the costs of the deposition, but I think that those costs have probably well been exceeded by the briefing that's been expended on this motion for protective order. So we'd ask that it be denied.
All right, so you said there are 4 outstanding requests that haven't been fulfilled?
Correct.
Attorney Stadler, what about those 4 outstanding requests? Would Mr. Richter have information on those?
He would not, Your Honor, because the requests ask for a search to be made, and that for the period of time was from when the request was made and the date specified therein until the search was performed. And that exhibit that we filed with the court today shows that all of those searches have long ago been performed. Now, it kind of begs the question. I still don't understand why we're here in a mandamus action where your remedy is give me an order to say produce or to respond to a record that you haven't responded to, and we keep hearing that we've got these requests that haven't been responded to, but the plaintiff never brings it forward and says, Judge, give me my mandamus. I mean, that's what this case is about. Ask the court for the mandamus and get your order commanding us to respond to it. I don't understand what we're doing with all of this discovery when the issue in the case is you haven't responded, judge, order them to respond, and they won't bring that forward. Mr. Richter has nothing to do.
Let's back up to this Amanda person. Do you have any information as to where she is?
I do not know where she lives. I know that she worked in the Speaker's office. She left sometime late in the summer, early in the fall, and all I know is that she moved out of state. I don't know where she is. I don't have an address for her. I've never met her in my life.
Else?
Never spoken to her.
Is there anybody else on these lists, open records checklist, that is still around? I mean, there's a number of individuals on this list.
Ms. Lutke is the only one I'm aware of who is no longer employed in the Speaker's office. I can't say I'm 100% certain on that, but nobody has said to me, this person isn't here or that person isn't there. But I think that the important thing to keep in mind as well, Your Honor, is that people are asked to search the records that they have. So to use an example, Chief of Staff is Jenny Toftis. She's asked to search her email account in regard to, do you have records that are responsive to this? So no one employee is going to be able to tell you, here's what everybody did, because everybody in the office is charged with to search what they have. There's not one comprehensive search person who says, I'm responding to this. It's all assigned to them by Mr. Fawcett and then funneled back through Mr. Fawcett. So when counsel says I haven't given them anyone else, I don't know who to give them because I'm not entirely clear what they're trying to do. If they want to ask the person who searched Representative Voss's phone for some emails or text messages, it would be Ms. Lutke.
May I respond to that, Your Honor?
You may.
Thank you. What we told counsel is that we're trying to get to the people who operate, most particularly the Rep Voss and Robin Vos legislative email accounts. And we're told that those administrative staff can do that. But the interrogatories that we've received from counsel also show that a number of staff members have access to those accounts. And we've just never been provided a different person other than Ms. Richter and Ms. Ledke, or Mr. Richter and Ms. Ledke, who could provide that information. Now, relative to our motion to compel, we've also asked for written interrogatories that would help us answer some of these questions. But the discovery so far has not informed us who is really keeping track of requests related to these accounts and ensuring records aren't deleted, and who can tell us whether records American Oversight requested were deleted. and again, the overall environment makes it very likely that records were deleted. So it's very important that we get to the bottom of this information, and it's not irrelevant to ask for it in a mandamus action. Most mandamus actions that I have are a summons and complaint process where there is discovery and there is summary judgment to resolve the issue. So that's how I envision this being resolved ultimately.
Have you meet and conferred about the defective or what you feel are defective answers to the interrogatory?
To an extent, we've attempted to. We sent a letter to counsel on 15th. It's document 73 in the docket, identifying these issues. And we have not, we asked for a response by January 26th, and we only got a partial response, not relevant to the issues we're bringing forth in the motion to compel. I suppose one other thing I would add, Your Honor, is that the sheets that were submitted as this exhibit today, it is not exactly clear what they show, but if records were collected in response to the 4 outstanding requests, or have been searched for by at least some staff already, those have not been provided to us, and it's unclear to me why not. And again, Mr. Richter could tell us, I think, what the status of those records is, as somebody with access to the applicable accounts.
But he is not the records custodian. He hasn't been designated as the custodian. He has no part in responding to records requests. He doesn't know the status of things.
All right, this is what I'm going to do. At this point, I don't think Mr. Richter has enough information, since he started after this all occurred, to really be useful in the deposition. However, I do see that the responses, I'm going to have the parties meet and confer regarding the defective responses to the written discovery. And if the parties cannot reach an agreement on some of these issues, then I will decide them. But it seems to me that I have told both sides, and I'll reiterate it again, what's relevant here is the documents that are responsive to the document request, and if there aren't any, which again, there doesn't appear to be many, were they destroyed? Were they destroyed? And I think those are relevant. I will order answers to interrogatories because there's gaps here now that under the depositions that they say these records were, or these requests were made on such and such a date and never responded to people until 17 days later or days later. And that's a concern to this court. You can't, once you got an open record request, you're supposed to preserve the documents. There should have been a litigation hold or a email sent out saying, we've got this open records request, you need to make sure you don't destroy it. So I think if these records, I think what's relevant is when these records are deleted and why they're deleted after these open records requests. And that's what was requested by plaintiff. I want you to meet and confer and go through this. If you still can't resolve it, then let the court know, and I'll have a hearing on this, an evidentiary hearing. But right now, I am going to allow Mr. Richter not to have to sit for a deposition if he is not he was hired after these open records requests, which should have occurred prior to his hiring, according to Attorney Stadler, and that needs to be confirmed as well. And he can talk about current practice and procedures, but to the extent that there are changes in practice and procedures, I think that's a interrogatory or a document request that needs to be responded to as to what was in place to make sure that these documents weren't destroyed at the time these open record requests occurred. I'm concerned that we seem to be spinning our wheels and that there isn't been a fair and frank discussion of the issues of this case, and that just makes everything more time-consuming and expensive. And if there are deficient requests, and I find there's deficient requests, I do have ways of complying with the deficient requests, and I will entertain any requests, or I don't know if I can sanction anybody on this, but this has got to stop. Either these records exist or they don't, as I said all along. If they were deleted or destroyed after an open record request was made, I think that's relevant, and I think the court needs to hear that. In the meanwhile, Mr. Richter does not need to be deposed at this time. All right, any questions from anyone?
If I could just raise 2 points, Judge. First, I don't want to leave the court with this taste in your mouth that somehow we concede that there were records that were deleted. The deposition testimony from Mr. Voss and Mr. Fawcett has been that records do get deleted, but they do not delete records while there is an outstanding records request. And so I don't want the court to think that somehow we agree that there's this proof out there that we have this problem, this dangerous problem, as plaintiff calls it, of records being deleted, because that's not the case. So I just want to be clear on that. The second part is just in regard to the court's order to meet and confer. We will certainly do that. Counsel for the plaintiff had raised in her brief an issue that is percolating between the parties, and that is the plaintiff's request to do a designee deposition, which I've never before seen done in public records litigation. I would just advise the court that I intend to confer with counsel on that too. But if we can't reach an agreement on that, we may present that as an additional issue to the court.
All right. One of the concerns the court has, and that's fine, I'll address that, is not that an open records request, it may be that an open records request came in, but if the people that are supposed to be searching their emails don't get that request for 17 days or however long it was, they could delete their emails without even knowing it was there. And I think that's a proper inquiry. Not that they intentionally did anything, but if there aren't procedures to say, hey, we have this request, stop deleting your emails, that may be responsive to it, and they don't know for what? Attorney Westerberg, how long of a period of time was it?
It's anywhere from a few days to 13 or more days.
All right. So if they don't have any understanding that there's this request out there for 14 days, 2 weeks, that's a long period of time in which people may have inadvertently destroyed records, and that is important to know. So I am not going to reschedule the summary judgment on this until after the parties meet and confer, because I have a feeling we'll have another hearing on this. Once we get the issues addressed, then we'll set the scheduling. Okay?
That's
Thank you.
fine by us, Your Honor. Could we set we share the court's concern about we're spinning our wheels. We feel like we keep asking for this information and we keep not getting it. And it would be good to have an outside deadline for the meet and confer. And, we're also cognizant of, the fact that this is an open records case and they are intended to be addressed quickly so that the public can have access to which it is entitled.
All right, well, the meet and confer should be by next Friday, the 18th.
Thank you.
All right,
Okay,
anything else?
Krista, I'll contact you about a date.
Sounds good.
Attorney Westerberg and Attorney Stadler, you can put a order together based on today's hearing and run it by each other, and then the court will sign it when I get it.
Thank you.
Your Honor.
All right? And well, let me actually back up. I want you to meet and confer a little sooner, because then if you can't agree, you're going to have to you'll file something. So let's have you meet and confer by next Tuesday. Any filings are due at the end of next week, next Friday.
Could I just ask the court to make that Wednesday? I'm just completely booked like every day between now and Wednesday, Judge, and the 16th was going to be the
That's
date
fine.
that I offered Ms. Westerberg.
All right, that's fine. Next Wednesday. All right? All right, thank you all. We're adjourned.